Here you are.
Good morning. My name is Sarah Pellenbarg, and I represent the appellant and the appellee in this case, Moniz Etienne. I'll discuss the merits appeal first, if that's all right. It seems to make the most sense logically. We are here on appeal of the trial court's order granting directed verdict in favor of the defendants on Ms. Etienne's claim for false arrest. In granting directed verdict, the trial court ruled that as a matter of law, Ms. Etienne could not support her claim for false arrest and implicitly accepted one or all of defendants' arguments, which included, number one, she was not detained against her will because she had a reasonable means of escape through the doors of the Walgreens. Number two, that she voluntarily agreed to stay as a matter of law in the store. And number three, that the assistant store manager, Mr. Venegas, had probable cause as a matter of law to stop her. We, however, believe there was a dispute of fact as to each of these issues, and for that reason the case should have been sent to the jury. Now, before I discuss these issues, I want to make it clear what we had to prove with respect to our claim for false arrest. False arrest is often interchangeably referred to as a false imprisonment claim. They're, for all intents and purposes, the same thing in the case law. And what we needed to prove was the unlawful detention of a person against that person's will. So we needed to prove that there was a detention against that person's will, and we have to prove that that detention was unlawful and unwarranted. With respect to the first element, the law is clear that you don't need to be physically restrained in order to have a claim for false arrest, that words or threats can be sufficient. And number two, that you don't need to make an oral protest to demonstrate that the stop or the detention was against your will. With respect to the element as to whether the detention was unlawful and unreasonable, the other side can come back, and if they can demonstrate that they had probable cause as an affirmative defense, then they are immune from liability for a claim for false imprisonment. Now I'd like to address each of the three arguments that they made below. First of all, was there a reasonable means of escape in this case? We know Ms. Etienne testified that when she purchased her items, she was leaving the store. Mr. Venegas stood between her and the door and argued for 20 minutes as to whether she had taken anything. He said, you took something, show me the inside of your purse. She said, no, check the store video. He ignored her, show me the inside of your purse. At page 1021 of the transcript, she confirms this went on for 15 to 20 minutes while he stood between her and the door. He then made a phone call from the nearby cashier desk, telling the cashier there to watch her while he made this phone call.
Well, let me just interrupt you, because it seems like to me one of the big problems that you have in this case is her testimony that she agreed to stay.
That's a separate argument that they made. What she said, in fact, is, I agreed to stay because I knew that if I left, they were going to chase me or they were going to send the police.
What difference does it make why she agreed to stay? She agreed to stay.
Because it has to be against her. They have to demonstrate that she stayed there voluntarily, that it wasn't against her will. So did she willingly stay in this store? Or is there a dispute of fact as to whether she truly voluntarily stayed in the store? Remember, he blocks her exit most of the time. She's a 19 to 20-year-old girl. He has his cashier guard her, and after he makes the 911 call, he guards her again. Why are they guarding her if she's free to leave? And she says, the only reason I stayed is because I didn't have a choice. So this sort of, isn't it true you agreed to stay, ma'am? I mean, she stayed because she had no choice. And that, they harp on this case Gatto, the Gatto case, the public.
Well, she thought she had no choice. Wouldn't that be more accurate?
Right. Could reasonable people find that she had no choice, or that she believed she had no choice? And that's really the key here. You may think that she stayed there voluntarily. I may agree, she may agree, we may all agree, but could a reasonable person find that she didn't agree to stay, that in fact she only agreed to stay because she had no choice, that it wasn't voluntary, but that she stayed only because she had no choice, it was against her will? And we believe there's a jury issue. This Gatto case, if you look at the Gatto case, that's the case it's a public supermarket case. The plaintiff was suspected of taking a book. And the court, it was his book the whole time. And the court said, in that case, there was clearly no jury issue because Gatto wanted to stay. He called the police. He was the one who said, call the police. There's something wrong here. Call the police. I didn't take anything. How can you hold the storekeeper liable in that situation where Gatto was the one to call the police? Our case is completely different. And back to the argument on whether she had a reasonable means of escape. Again, there's a physical barrier. He's standing between her and the door. He's yelling at her.
He wasn't standing between her and the door the entire time, was he?
She testified, and I can give you the transcript pages at 10:18 to 10:20 on Volume 8. She testified that he stood between her and the door for the first 15 to 20 minutes while they argued. He called from the nearby cashier desk, which must have been behind her, for however long it takes to make a 911 call. And then he returned and stood between her and the door, guarding her until the whole incident was finished with the police officer becoming involved. And frankly, I don't think it matters that he stepped away, because even those first 15 to 20 minutes of him arguing with her would be sufficient to create a jury issue as to whether there was a detention in the case. Bottom line is this case should have gone to the jury, and the trial court ruling as a matter of law on this case is what created the problem. I'd like to reference the McCann case too. That's a First Circuit court case. First Circuit case. I realize that's not Florida law. However, it applies Maine law, which follows the restatement. And that was a very similar case in which the customers were suspected of taking something, and they're instructed to come to the front of the store. They're sat against this wall, and they're guarded by the employees the whole time, and they're told, we're calling the police. And the court said in that case, and I'm going to quote from them, that the direction of the McCanns, the reference to the police, and the continued presence of the Walmart employees were enough to induce reasonable people to believe either that they would be restrained physically if they sought to leave, or that the store was claiming lawful authority to confine them until the police arrived, or both. And the court held there was a jury issue in that case. Again, look at the Spears case out of the First District Court of Appeals. That's a case that's similar to our case, in which the employee was suspected of taking money. She was called to the manager's office. Her testimony was that he told her she couldn't go because he was calling the police, and he blocked her exit. Well, that's what we've argued here. She testified he blocked her exit, and he not only threatened to call the police, but he told her she was going to jail. As in, I'm bringing the brute force of the police behind me. You are going to go to jail. You're not free to go because you are going to jail. This is a very intimidating situation for a young 19-year-old girl. The other argument that they make is as to probable cause. Did Mr. Venegas have probable cause as a matter of law? If he did, then we shouldn't be here. Well, he did not. There was clearly a debate. It's a he said, she said situation. He said that he saw her take something. She said she didn't, and she didn't have anything on her when she was finally stopped. He doesn't have the backup of a video camera or a witness or anything. This is a quintessential he said, she said situation. With regard to probable cause, they cite two cases which are completely distinguishable, Kincaid and the cash and carry food stores case. In those cases, what happened is the two plaintiffs involved in those cases, they had taken food. One was a seed packet, one was celery. They were concealing the food. There's no dispute they were concealing the food. They were stopped, and the court held that there was probable cause as a matter of law. Those are distinguishable. In cash and carry, for example, they argue, well, she walked away from the manager, and the fact that she disagreed with the manager gave him probable cause as a matter of law to stop her in that case. Well, that's not true. What happened in cash and carry is she walked away from the manager after he saw her put celery in her purse, and she had celery in her purse. That's the distinguishing factor. It's not just that he stopped her and she walked away. It's that he stopped her and she walked away, and there's no dispute that she had the product in her purse.
But you're not saying probable cause turns on whether ultimately they're proved to be correct.
The bottom line is that no one was challenging probable cause. There was no evidence to rebut his argument that he had probable cause as a matter of law, because the plaintiff in those cases didn't have the product on them. Did have the product on them. And she wasn't disagreeing with that. She was just saying, oh, I was holding it while I was walking through the store, and then I was going to pay for it, or I forgot to pay for it. But that's different. It's different in our case, where we're coming back and saying, not only do we disagree with you, we didn't even have the product on us. I mean, it wasn't on her. And there was nothing to suggest that she took anything other than this random out-of-place eye cream on a shelf that the police found later, and he thought that she'd taken deodorant. So that's simply not enough to resolve the issue of probable cause as a matter of law. I think the real issue in this case is the public policy behind this case. Because what you have is you have a situation where this man, and we do have to take the evidence in the light most favorable to the plaintiff. So we have this man who's yelling at her, and she's a 19 to 20-year-old girl from Haiti. You know, he's yelling at her, show me the inside of your purse. I mean, that's a big deal. This is protected by our Constitution, your right to privacy. She didn't take anything. He's yelling at her for 15 to 20 minutes. He tells her she's going to jail. He doesn't offer her a chair. He doesn't say, go wait out of the eyes of all these people. It's a busy time in the evening at the Walgreens. I mean, this is a very intimidating situation, and it was incredibly humiliating for her. And what we're telling people is we're saying, you know what? It doesn't matter because there's no detention. What we tell the stores here, there's no detention in the first place. You can do whatever you want. So not only can you yell at her, tell her she's going to jail, but you can do so even if you have no probable cause, even if you have malice. I mean, that's what they can do because there's no detention as a matter of law. I mean, that's what the trial court said here. And that's not a good balance to strike in this case. Because in this case, the statute alone is enough balance. The statute says if there's probable cause, the merchant's immune. He's off the hook. So let it go to the jury. Let the statute work itself out. Let the jury decide whether he had probable cause and, frankly, whether there was a detention. We shouldn't be resolving this issue as a matter of law. We should let her have her day in court and balance the store's, the issues for the store and the incentives for the store to instill policies that are important to balance, balancing the rights of the customers with the store. And think about what happened to the customer here. She really, when you think about it, did quite a brave thing. Because most of us, if we were faced with that situation, or not necessarily most of us, but some of us, would say, oh my gosh, I'm in shock. Why is this person asking me to show the inside of my purse? And then you'd show it and you'd be on your way. And then half an hour later at home, you'd think, oh gosh, why did I do that? I should have done something different in that situation. And what we want to do, what she did was brave.
Why isn't it reasonable just for her to say, look, I didn't take anything, I'm going home. Do what you want to do.
Well, she thinks the police are coming after her and will be chasing her, and she's intimidated by the...
She said she felt she was free to go, so she
I don't think... See, everyone keeps saying that she's free to go, but that's not the full sentence of what she said, and I think that's important to say, and I think that does create a jury issue. And I'll read to you exactly what she said. I was thinking if I leave, they're going to catch me anyway, and I don't have anything in my purse, and why should I leave? Because they're going to send the police to chase me anyway. So technically, are the doors going to open? Can she walk outside?
Well, read the rest. So what you're telling us is you agreed to stay there, is that right? Yes, sir. In addition to that, am I correct, ma'am, that no one else from Walgreens prevented you from trying to leave the store in any way? Yes, sir.
Was it voluntary, though? The semantics of her saying, as a 19-year-old in response to a question, isn't it true you agreed to stay? Yes, she agreed to stay, but she only agreed to stay because she felt like she had no choice. So, yes, the double doors are going to open, but how far is she going to get?
That's not what she said, though. Even reading her testimony in the light most favorable to her, she didn't say, I felt like I had no choice.
Did she stay? Was her decision to stay truly voluntary? I think her statement demonstrates that although she technically agreed to stay, I hate to bring up the obvious example of like my kids eating their Brussels sprouts, but when
this is not your kid. You've said several times she's an 18, right, exactly. She's a grown-up woman. It's not your kid eating Brussels sprouts. She thought she could go. She chose to stay because she felt she hadn't done anything wrong. End of discussion.
We have a store clerk who's guarding her. Why is he guarding her? If she's free to go, why is he standing there guarding her? Why is he standing between her and the door? That alone to me is enough to suggest that she could have made a run for it, but she suggests that they're either going to follow her or they're going to send the police after her. She doesn't know what's going to happen. Should she have left? Do we want to encourage in this situation people to run out the door? Or do we want to encourage people in this situation to do exactly what she did, which is stay there and let the police sort it out? And then later, if there was no probable cause, if someone has wronged her, she can go to court.
Why would she have to run out the door? Why couldn't she calmly walk out the door to her car, get in the car, turn it on, and go home?
And then,
is anybody telling her she can't? Did anybody?
No one's telling her she can leave either.
Well,
She's
saying that she felt she could.
She's saying...
But we can go round and round. It says what it says. You know, it's in the eye of the beholder, I guess. But it just doesn't seem as egregious as you feel that it is.
I just wonder if reasonable minds could differ on this issue.
I guess they are differing.
I think they are. Well, I'll
go ahead.
I think the point being is what should the public policy be in this sort of situation? You know, what's going to happen if she calmly walks out the door? Are they going to chase her?
Who knows?
Maybe they would have. I mean, is that what we should encourage to happen? Do we want the police chasing her down? And I mean, I think what we want is for her to stay in the store. And all we're not saying let's give her tons of money. I mean, we're saying this woman feels violated, and she wants to argue to the jury that she was wronged. Win or lose, she wants to make this argument. What this trial court has said is you have no recourse for what happened to you at all.
Should we at all consider what happened to the 3 claims that went to the jury, or is that not?
Those are completely irrelevant, and they require completely separate elements of proof, and therefore we don't believe they overlap. And if you'd like me to address any of those in specific, I'm happy to.
Okay.
So the bottom line is we believe that you should, in fact, hold that there was a dispute as to all of these issues, and that she's entitled to a jury trial in this case.
Okay.
Okay, thank you.
Thank you.
Oh my God, thank you. All right, I will briefly discuss the fee appeal. Is that what
Can I ask you one more thing?
Absolutely.
I believe I'm looking at the jury instruction on the topic we've been discussing, and part of the jury instruction says a person is not restrained when there is a reasonable means of escape, which is apparent or known to the person.
Correct. And what that reasonable, and what we have here in terms of the key is the word reasonable. Is it a reasonable means of escape in a situation? Courts have held that when someone is blocking a door, like in the Spears case, that creates a jury issue. And she makes that argument here. We also have the fact that she's being guarded, which we think prevent the sort of reasonable means of escape in this situation. And I think most of us, if we put ourselves in that situation, is that really a reasonable means of escape given the fact?
Escape almost implies, though, it almost suggests that a person would be required to run, if you will, or dodge, or duck and weave, as opposed to just, in other words, the instruction seems to authorize and even encourage a more aggressive tact when one finds oneself in this situation than what appears to be the situation here, where she wouldn't have had to necessarily escape.
I mean, I think that's probably a problem coming from the law that combines false arrest with false imprisonment, and there's been some muddying of that. But certainly, there's a statute dealing with store merchants in this case, and that's meant to address this very situation where, the escape is going to be out the front door, and they're not going to be tied down. It's that sort of situation. So I don't think that that's a particularly relevant factor to this particular case involving a store merchant.
Okay, what we're going to do on the fees, I'm going to treat it like a cross appeal. So I'm going to let her respond to you on the merits.
Okay.
And then give her initial argument on the fees. And then when you get up, you'll have some time to reply on the merits and then respond.
I understand.
And I'm keeping track of all this time.
Okay, great. Thank you.
Okay.
May it please the court, Elizabeth Russo on behalf of, in this case, the appellee Walgreens, or at least for this first part. It's our position that the trial court was correct in his ruling and should be affirmed. This case went through 5 years' worth of discovery getting ready for trial, and when the parties arrived at trial, the plaintiff was allowed to testify however she wanted to. What you will never find anywhere in the transcript was the word guarded, for one thing, and you'll also never find anywhere where the plaintiff said that she thought that she was afraid, that she stayed because she was afraid of the manager.
Does she have to say it? I mean, if Ms. Pellenberg raises a good point that if the store employee is standing between her and the door and yelling at her for 15 minutes,
The actual, well, I'm sorry, Your Honor.
Go ahead. Does she have to actually say the words that she did not feel free to leave?
Well, I'm just going by the plaintiff's testimony, and the plaintiff's testimony, as far as this arguing was, is that she was very angry, and she was speaking loudly and strongly to the store manager. So they're arguing back and forth, but what she doesn't say is, and because of that, I felt I couldn't leave. She was there to tell him why she didn't think she should have to open her purse, and that she wanted him to look at the video or whatever, but she does never say that she didn't feel that she could leave. And she says that, yes, that he wasn't there the whole time. There was no other employees who tried to stop her. But I think the most important thing is just her own explanation. She was allowed to give her explanation of, well, what was happening. And she said, well, her lawyer said, in closing, he says, they had no problem with him calling the police. He says, I'll give him the benefit of the doubt when he called 911. He's a manager. If he saw something, he's a citizen, got no problem with him calling 911. All right, so from that point, they don't have any problem with him calling the police, and her explanation of why, what that meant to her was, all right, the question is, he wasn't there all of the time, true? Yes, sir. Can we also agree that no one else from Walgreens prevented you from leaving the store that evening? And then this is her explanation. She says, I was thinking if I leave, they're going to catch me anyways, and I don't have anything in my purse. And why should I leave? Because they're going to send the police to chase me anyways. That's what was going on in my head. She knows that she can leave. It's just a question of she makes the choice. You're telling us you agreed to stay. Is that right? Yes, sir. She knew that she could either leave and talk to the police somewhere else, or she could stay and talk to the police there. She didn't have any problem with the police being called. She chose, all right, well, I'm going to stay here and talk to them because I don't have anything in my purse. And that was her choice. That's just not a false arrest. It's not a false detention. And I think the judge was exactly right. There's not more to be had or more to be said. That's what happened, according to her. She knew she could go or she could stay. She was going to talk to the police one place or the other. She admitted she was young, she was angry, she was yelling at the manager, she yelled at the police. She probably should have just showed the police inside her purse. But what she doesn't say ever is, I stayed there because I was afraid. Nor is there anything from which you would draw that inference. That just wasn't her version of the story. So I don't think that they met the elements of showing a false arrest. And this is not necessary, but also the directed verdict was at the end of the evidence, and so the the defendant had already put on the affirmative defense as to the probable cause, and the cases are sort of all over the place. Some of the facts are similar, some of them are different, but the one case I think that is on point is that cash and carry case, and that was the one where the manager approaches a woman, he thinks he's seen her put something into her purse, and he asks her about it, what happened to those green things that were in your grocery cart? And instead of responding to him, she walks away, takes her cart and starts walking away. And the case says that as a matter of law, once you have, whatever the suspicions may have been to begin with, whether one was right or the other, whether that would be probable cause is one thing. But once the customer actually does not respond to you or does something to in effect confirm that there's a problem, then you have probable cause as a matter of law, and that's what they held in that case. In fact, I think it was a summary judgment, or it might have been directed verdict. But one way or the other was decided as a matter of law. So once she makes the choice, okay, it's not just a question of we have a disagreement about whether you saw something in my purse or not, but I'm going to yell at you, and I'm going to resist, and I'm going to say I won't show you my purse, and I'm not going to assist the merchant in dispelling the suspicion, then as a matter of law, that's probable cause, which would be another reason why, under the statute, it would be that he has immunity, so that there would be no cause of action for false arrest. But I think it really all just comes back down to her giving her own explanation of what happened, and it wasn't one that said, I stayed there because I was afraid, or I was intimidated. So we would ask that the final judgment that was entered based on the directed verdict be affirmed. Unless there's other questions on that.
No.
On the attorney's fee, this was, it was based on our proposal for settlement. We had asked for fees, and the plaintiff opposed the motion below on grounds that while we proposed that there be a release, we didn't actually attach the release to it. There have been other grounds raised on appeal, which I'll address as well, but as to that one, they said that the fee proposal was ambiguous because of the release not being attached. But what the actual proposal said was that the release will be in a form negotiated by the parties and of the type promulgated by the Florida Bar Civil Trial Lawyers section for such matters as this, which I think is simple enough. You can get the Florida Bar Civil Trial Lawyers form release right off of their website. And it's just a general release, as simple as they can be. I think I reproduced it in my brief. And I think that the adding the negotiated by the parties, if anything, just means this isn't going to be a surprise cram down from the defendant. It's going to let your lawyer have a say in it as well, but we're talking about a general release.
But the Florida Bar form varies from case to case.
Well, I think he said in matters such as this, and I think it's a tort case, so I just looked at the tort one. I just got the one that you would use in a tort case. I think the other ones would be the only one applicable. But it is just a general release form.
That permits you to change the variables.
Well, I mean, it's said to be negotiated by the parties, but but it wasn't any. There's nothing fancy about it. Just not having lots of terms or anything. It's just saying
but is it specific
we'll release everything
as the rule requires?
The rule said, well, there are cases that we cited that have said that, yes, well, it's best to attach the release, the exact one that you're going to use. A general release is also acceptable. I think that this case, I mean, as a matter of fact, this court in the Carry-All Transport versus Newby case said a general release is sufficient to allow a plaintiff to decide whether to accept or not. Meaning it's just, I mean, this is one defendant, one plaintiff. The defendant is saying, I'll give you $7,000, and in exchange for that, you're going to release the causes of action that you brought in this suit, which is the way it was put. And that's what this court seemed to think. And also in Jones versus Publix, the 4th DCA case we cited, it was also, it was a reference to a general release. They hadn't actually titled it, and the court said that's sufficient to allow someone to know what a general release is. I think, in fact, the Supreme Court in Nicholson versus State Farm, which was one of the ones that addressed this, when is a release ambiguous? They said that the release in that case, the general release was ambiguous because it was known that the plaintiff had a PIP claim and also a UM claim, and the release was being proposed just in the PIP case, so that did create an ambiguity. But they said, we're not trying to change the law of general releases or rework the whole thing. Unless there's a general ambiguity, I mean a genuine ambiguity that's going to make the plaintiff be unable to accept or unable to assess whether to accept or not. I mean, Judge Voluntarily said in the Carry-All Transport case, parties should not nitpick the validity of a proposal for settlement based on allegations of ambiguity unless the asserted ambiguity could reasonably affect the offeree's decision on whether to accept. And I think a general release is not something that you would not expect in exchange for funds. There's also, just briefly, there was the other couple of arguments that have been raised on appeal that were not raised below. There was a question brought up about the inclusion of their claims handler, Sedgwick, I think is the name of it, because the plaintiff had taken a couple of depositions of some of the Sedgwick people, but they were not a party. They've said that that should be treated, therefore, as a joint offer because we wanted a release of both Walgreens and Sedgwick, but that proposition has been rejected by this court, again, in Carry-All Transport. They said that only refers to if there's an offer being made by two parties, by or to two parties. But we went through a discussion of the whole thing. Said in Carry-All, there had been, the defendant was Carry-All Transport, and there had been a prior employee that had also been sued by the plaintiff, and the plaintiff then dismissed that prior employee. So when the settlement was proposed by the employer, Carry-All, they were asking for a general release of including all employees and so on and so forth. And so there was a question raised about, well, does that make it a joint proposal that has to allocate between the two? And this court said no, because the former employee was no longer a party. So it says, thus, even though Delorme was obviously a person interested in the litigation, he was not a party to the litigation, and apportionment was not necessary. Logically, an offer cannot be joint where the only party in the lawsuit is the one making the offer. So the idea that a non-party, that you're asking for release of a non-party does not activate you have to apportion or make it a joint offer, at least according to this court, and carry all transport, and I think correctly so. Then there was also a question raised on appeal about the fact that there was no mention of whether attorney's fees are part of the legal claim. The proposal did say that it's inclusive of any attorney's fees and costs that may be claimed. But the key thing here is that the plaintiff never claimed attorney's fees. They didn't allege them in the complaint. They have no statutory right to, or she didn't have any contract right, and they were never part of the case at all. So the plaintiff's decision as to whether to accept this proposal could never have been affected by whether the phrase part of the attorney's fees or part of the legal claim was or was not included in the proposal, and that's what that 4th DCA case in Bennett versus American held. If there was never any claim for attorney's fees to begin with, it really doesn't matter for purposes of the proposal for settlement. If it mentions attorney's fees or wrote not applicable in or didn't rather to. And I acknowledge that the Supreme Court mentioned Bennett in its Diamond Aircraft case versus Horowitz, which we've cited, and said that was questionable whether that would continue to have effect, but in Diamond, there was a fee claim. It was alleged in the complaint, and so the Supreme Court just sort of left Bennett to the side, as not really decided one way or the other what they would do with it. But I think that if there is no attorney's fee claim, it really can't matter at all. And in Bennett, they also said, since they mentioned that it was going to be inclusive of costs, that's good enough too. And here we actually spelled out fees and costs would be part of it. So I don't think that that was enough to invalidate the proposal in any way. So the relief that we would have to request is that it really depends on the outcome of the main appeal also. So if the final judgment is affirmed, as we are requesting, we would ask for a reversal of the order denying fees with a remand for the court to award an amount. If the court reverses the final judgment for a new trial, we would still ask that there be a reversal of the order denying the fees with an amount to await such time, if ever, as we find out if the plaintiff does or does not beat the proposal. If there's no other questions, none. Thank you.
Thank you.
Just want to briefly touch back on this agreed to stay. I know we've talked about this for a while. I think there is a debate in the evidence, and I just want to summarize our position. She said she agreed to stay basically because she had no choice. Does that make it against her will? We think that reasonable minds could differ on that she wasn't staying there voluntarily, but because of this pressure, because she was going to be chased. Does she have freedom of movement at that time? Can she go home and hang out, or are the police immediately going to be on her? She's been told she's going to jail. That alone is enough evidence to show that she didn't voluntarily agree to stay, but was under pressure to stay. That's also consistent with the fact that she didn't move the entire time. She didn't sit. She testified she was upset. She testified he was yelling at her. Not just her statement in this transcript, where, goodness, it's a shame that she used the word agree. If she hadn't used the word agree, would we be talking about this differently? Because what she said is, I stayed because I didn't have a choice. I hate for her to throw her whole case away because she answered a question that was, isn't it true you agreed? Yes, I did. Really, it was this tremendous pressure on her to stay that forced her to stay, and her actions beyond her words show that she was afraid. She was very emotional, very upset. She's not a child like my children, but she is a 19-year-old girl from another country, and I think she was in complete shock, most likely. And the other point I want to make on this is, you know, should she have just casually walked out the door and seen what happened? Or do we want her to stay? I mean, wouldn't we want her to stay? And that way she can go to court if she has a cause of action. I mean, what if this guy's acting with malice? I mean, I'm not saying he is. What if he was, though? I mean, she doesn't get to go to court and prove that. If she's singled out for improper purposes, the court here has just said, well, too bad, you know? I'm sorry that you had a bad experience. Next time, maybe she should walk out the door and then see what happens after that. It's not the right message to send. I want to talk about the fee appeal now. There's many problems with the offer of judgment that was served in this case. First, it didn't summarize the release with particularity, and when it did summarize created an ambiguity. And second, it didn't include a statement as to whether attorney's fees were included and whether attorney's fees were a part of a legal claim, which is required under Rule 1.442. We didn't make that second argument below. However, under Tipsy-Coachman, this court can affirm if the trial court reached the right result, even for the wrong reason, so long as that appears in the record. And that's true even if we didn't make the argument below. And that is the WQBA case out of the Florida Supreme Court that makes that point. Here we have this broad language regarding the release. We need to execute a release of the type promulgated by the Florida Bar. There's no direction as to where to find that in the offer. And to be negotiated by the parties. Now the Florida Supreme Court is moving towards this more strictly enforced concept of enforcing Rule 1.442. You're required to describe your non-monetary terms with particularity. What does particularity mean? Does it just mean execute a release that's going to be negotiated in the future? It must mean more than that. And because the Supreme Court is moving towards more strict construction, we believe that this just vague language would be insufficient. And certainly courts have already held this sort of language as insufficient, like the Mix case out of the 5th District Court of Appeals. But really the bigger problem here is what is described creates an ambiguity. The offer says that the plaintiff must release all claims brought pursuant to this claim. All claims brought pursuant to this claim. That's awkward language to say the least, but it says all claims brought, so that must mean past claims. Well, the problem is now that we have been directed to the trial section of the Florida Bar and the sample release that they direct us to look at, that language suggests that we'd be releasing all claims arising out of the incident in the first place. So past claims and potential future claims we would have. So which is it? Is it all claims brought, like they say in the offer? Or are we releasing all claims brought and potential future claims arising out of this incident? And there's a conflict there, and we would have needed clarification. If it's past claims, how do we release a non-party from past claims? How do we release Sedgwick, who's their lost claims management company, from claims that were brought? We didn't bring any claims against Sedgwick. So that inherently creates an ambiguity. If they're suggesting that we're supposed to be releasing potential future claims against Sedgwick, well, we couldn't do that because we can't be asked to release a non-party or give up claims we wouldn't have otherwise had to give up in the litigation. The Nichols court makes that clear, and it would be improper to release a non-party or to require the release of a non-party because this is a very strictly construed statute. You know, this is a significant penalty, and you should be comparing apples to apples so you can, you know, see whether that 25% threshold is accomplished. And if it is, and we're requiring, oh, release all these other people too, I mean, that's not a fair way to use that statute, and the courts have held that that's inappropriate. Last but not least, Section D states there's no non-monetary terms in the offer. Well, obviously, if we're required to execute a release, that's a non-monetary term. So there's just many, many inconsistencies within the offer regarding the release, which render it unenforceable. The other problem is the offer doesn't state whether it includes attorney's fees. Instead, it just makes a general, it doesn't really take a position. It says if it does, then it's included. If it doesn't, then it's not included. That doesn't comply with Rule 1.442. This argument is highly technical. We totally admit that. But that's the way that the Supreme Court is moving now. Starting with the Campbell versus Goldman case in 2007, that's the perfect illustration of how strictly construed this rule and statute are. In Campbell, the offer stated that it cited the offer cited Rule 1.442 but didn't cite the statute. And the court held, well, this isn't ambiguous at all, but you didn't comply strictly with the language of the statute, and therefore your offer is unenforceable. And Justice Pariente made relevant comments in her concurring opinion that are relevant to this case as well. Certainly there was no lack of clarity, uncertainty, or confusion in this offer. Nor can it be said that failing to allow attorney's fees when there's such a technical violation vindicates the primary goal of the statute and the rule, which is to encourage settlements in order to eliminate trials if possible. And then she goes on to say, but because parties will now be on notice that all T's must be crossed and all I's dotted, there should be no further litigation on this issue. And then following Campbell, we get the Diamond Aircraft Industries case, and it addresses this very issue, and I'll read you the holding. Strict construction of Rule 1.442 required that Diamond Aircraft's offer of settlement include a provision with regard to attorney's fees and whether such fees were a part of Horwich's legal claim. Now, the appellees are arguing, well, that's distinguishable because in that case, there was a statutory basis for attorney's fees in the complaint. And here we don't have a basis for the attorney's fees. And they cite this Bennett case out of the 4th District Court of Appeals, which is an old 2003 case, precedes Campbell, precedes Diamond Aircraft Industries, and in that case, the court made the same observation. Well, you don't need to really include this statement unless you actually have a statutory claim for attorney's fees. But that's not what the rule says. The rule doesn't say you have to include it sometimes and not in others. It says you shall include this statement. And Diamond Aircraft Industries seems to squarely reject the Bennett case. It says, however, the 4th District decided Bennett in 2003, which was approximately 4 years before this court's 2007 decision in Campbell. And in Campbell, this court stated that all portions of both Section 768.79 and Rule 1.442 must be strictly construed, which draws the continuing validity of Bennett into question. And it goes on to say, we decided Campbell after Bennett, and in Campbell we emphasized the necessity of strict construction of Rule 1.442. Campbell dictates our answer with regard to the certified question, and then it goes on to make its holding that strict construction required a statement as to whether attorney's fees are included and whether attorney's fees are a part of the legal claim. That's what the rule says. State whether they are, whether they're not. Whether attorney's fees are included, whether they're not. You shall do this not in some cases, but in all cases. And frankly, it's not that hard. You say attorney's fees are not a part of the legal claim and they're not included, and each party will bear their own fees. That's what they should have done in this case. And so in conclusion, because the offer has some inconsistencies regarding the release and doesn't summarize it with particularity, and also because the offer doesn't include this statement regarding attorney's fees, we believe that the offer judgment did not trigger a right to fees in this case, and the trial court's order should be affirmed.
Okay, thank you.
On the issue of including Sedgwick, well, the description of the claims that are being released. Counsel's reading from the section about the release and what Moniz Etienne will sign a release of all claims. But the proposal says, this proposal for settlement is made to resolve any and all claims of plaintiff Moniz Etienne against defendant Walgreens Inc. as more particularly described in the complaint filed in this matter. Clearly, it's the claims that have already been brought, and then it goes on to say all the claims brought pursuant to. As far as the releasing Sedgwick as well, this incident, I mean, it's already been identified what claims are going to be, not that Sedgwick would have any reliability for them, but that it's for the claims that were of the plaintiff against Walgreens as described more particularly in the complaint, which arose out of the September 2004 incident that we've been talking about. This proposal for settlement was made on December 15th of 2010, which is more than 6 years later. Any claims that could ever be brought about for that incident that arose in September 28th of 2004 will be time barred. So I don't think that there's any problem, and as I said, this court has already said that there doesn't have to be any further. It's all right to include a non-party as part of the proposal. As far as the attorney's fee, when the Supreme Court in Diamond, that she was reading to you from about my Bennett case that said if there is no claim for fees, it doesn't matter if you include them in the proposal or not. All the bottom line say about it, the Supreme Court does, is it says it's called in the continuing validity of that into question, but it does not, although it could have said we're overruling Bennett because we've decided that you always have to be strictly applying the rule, and so therefore Bennett is now overruled. So I say that Bennett is still open, and it makes perfect sense if there is no claim and there never was any claim. The point of the proposal for settlement statute is to try to get cases settled where they can. You can evaluate whether you can accept the proposal or not, and here the plaintiff knew that attorney's fees had nothing to do with it. She never had a claim for them. That would never have entered the plaintiff's head or her lawyer's head in deciding, should we take this proposal or not? And when she was reading to you that they answered the certified question in the affirmative, the certified question that was pertinent here was, does Florida Statute 768-79 apply to case, no, I'm sorry, under Florida Statute 768-79 and Rule 1.442, is a defendant's offer of judgment valid if, in a case in which the plaintiff demands attorney's fees, the offer purports to satisfy all claims but fails to specify whether attorney's fees are included? So I think that question is open, and that here, given that there was no claim for fees, that the Bennett decision should apply and it shouldn't make any difference. I think that this was it's a one-page, very simple proposal for settlement. The plaintiff had every opportunity to and ability to decide whether she wanted to accept it or not. That she didn't want to accept it is fine. She didn't have to, but it wasn't a problem with the proposal. And so we would ask for the relief I previously requested in that regard. Thank you.
Okay, thank you both very much. And that concludes our session for today. Court is adjourned.